All rise. Oyez, oyez, oyez. The United States Court of Appeals for Veterans Claims is now in session. The Honorable Coral W. Pietsch presiding. All who have business before this court draw near, and you shall be heard. God bless the United States and this honorable court. Please be seated.
Good afternoon. This is Judge Pietsch. I'm appearing remotely, as is Judge Greenberg, and we are joined by Judge Appellant, who is present in the courtroom. We are convened today in this hybrid proceeding to consider arguments in the matter of William E. Terry versus Dennis McDonough, Secretary of the Veterans Affairs, case number 20-7251. Will counsel, beginning with Appellant's counsel, please enter your appearance for the court?
Yes, Your Honor. This is Matthew Greig and Kelsey Anthofer for Appellant.
Thank you.
Ronen Morris, with me is Christopher Wallace for the Secretary.
Thank you. Would Appellant's counsel like to reserve time for rebuttal?
Your Honor, we reserve 10 minutes for rebuttal.
Okay, fine. Thank you. 10 minutes. The counsel are ready. We'll begin with Appellant's counsel, Mr. Greig. Please.
Thank you, Judge Pietsch, and may it please the court. The issue on appeal today is the scope of the Board of Veterans' Appeals decision with regard to the veteran's sleep apnea claim. Now, the appellant asked this court to hold that where a claimant has continuously pursued a claim for benefits before the agency of original jurisdiction by filing a supplemental claim, that regardless of the AOJ's decision on that supplemental claim, the claimant is entitled to de novo board review of the entire claim on the merits, based on the whole evidentiary record as part of the veteran's statutory one review on appeal.
Mr. Greig, I hate to stop you right at the beginning. I just want to make certain something. The argument, the way you've just framed it, it really tracks a couple of the amici briefs that we've had in the case, and is slightly different than the argument in your briefing. So just so I'm on the same page as you, we wouldn't have to reach that full scope of your argument, which, as I understand it, is unrelated to time, right? Meaning any supplemental claim under the view you've just articulated and that the amici, a couple of the amici have, would encompass everything going all the way back to the initial rating decision if it's continuously pursued, right?
Correct.
However, your case presents a situation, if I'm right, in which your original argument was focused on the 1 year period, right? So if hypothetically we agreed with you on that issue, we could leave for another day the broader argument you're making. Do you agree with me?
I think that there's a practical aspect to this. And yes, were the court to agree with us today, as far as the timing aspect goes, that it may leave the question of the scope of the board's review. But I think the practical aspect here is that for Mr. Terry, and from the issues raised in the parties' supplemental briefs, that the parties largely agree on the scope of the AOJ's decision with regard to that supplemental claim. And when it comes to the scope of the AOJ's decision on that supplemental claim, that I think the statutes and the regulations all require that the board give a merits review of the claim as a whole. And when it comes to the AMA system and the new statutes and new regulations, that practically veterans would not be incentivized to file claims or file appeals, at the AOJ level of different decisions. In Mr. Terry's case, or in a situation similar to Mr. Terry's, I think the only reason a claimant would want to file an appeal at the AOJ, higher level review or supplemental claim, is to back out of the supplemental claim that was denied
for you, I just want to make sure that I have this factually correct, right? For you, Mr. Terry, he would be able to obtain the full merits review of the initial decision, the higher level review decision, based on your narrower argument that Mr. Terry filed the supplemental claim that was denied for no new and relevant evidence, and with some time remaining on that 1 year original clock, he appeals to the board. Correct. So Mr. Terry would be in exactly the same position under either version of your argument. Is that right? The narrower and the broader?
Mr. Terry would have, yes, Mr. Terry should have received a de novo review on the merits. And had the board considered the April 2019 higher level review decision to be the decision on appeal, then I can only presume that the board would have, given him the statutory one review on appeal.
Well, yes, I mean, the board could have made mistakes, but my point is because as judges, and particularly in a new, very complex system, I'm going to lay my cards out on the table for you. Whichever way I come out on this, I'm going to rule in the narrowest way possible because it is a complex system that's going to have quite dramatic effects, right? And so I just wanted to get on the same page that your what I'm calling your narrower argument, the one based on time, and the broader argument, I'm going to call it the continuously pursued argument. For Mr. Terry, they would lead to the same thing, which is the ability of the board to review fully on the merits the higher level review decision.
Yes.
Okay, great. I just needed to be on the same page. Okay, thank you.
May I, Judge Pietsch, may I make a comment or ask a question?
Please, go ahead.
Counsel, could you elaborate? I have a slightly different point of view than my colleague. What would be the benefits that you see, since you've raised the argument, of the court at least dealing with the so-called broader argument? What are the benefits to your client or to veterans at large?
Well, the benefit to Mr. Terry is he would receive a merits review of his claim by the board. So, of course, the board's decision, the June 2020 decision on appeal now, the board only considered whether there was new and relevant evidence raised with respect to the supplemental claim. So for Mr. Terry, he would receive the merits review of his claim based on the whole evidentiary record, and it would be the evidentiary record at time in place at the time of the decision on appeal. So if, for Mr. Terry, there had been relevant evidence submitted or added to the record between the April 2019 higher level review decision, which was a ramped decision. So the evidentiary record in place for the April 2019 decision here was the evidence, the record as it stood at the time the veteran entered into a grant. Obviously a little bit different than the AMA system now, where it goes back to the time of the last decision. So for Mr. Terry, the evidentiary record before the board would be different. And this goes back a bit to your question, perhaps, Judge Allen, that the evidentiary record available to the board may be a little more recent in time. And for Mr. Terry, his claim is wholly dependent on a diabetes claim. The sleep apnea claim that he's claiming arises out of the primary claim, which is a claim for diabetes related to Agent Orange exposure while in Thailand. With regard to the benefit for veterans,
before you get on to, and I want you to answer Judge Greenberg's questions about the benefits to the system writ large, which is how I understood his question. I did not follow your point that there would be a difference in the evidentiary record. Because as I understood your argument would be, you can review the higher level review decision. Okay? What I'm calling the narrow argument is you can do that because I appealed it within a year. The broader argument is it doesn't matter when I appealed it as long as I continuously pursued, the board can review it. Why would the evidentiary record for Mr. Terry be any different in either one of those scenarios?
Well, for Mr. Terry, he selected direct review before the board. And under the direct review lane, the board is deciding the evidence that was available or be part of the record at the time of the agency decision on appeal. So if the agency decision on appeal was the April 2019 higher level review decision, that would be the stop for the evidentiary record that the board would then review. But if the, and this is also partially hypothetical, if new evidence had been added, and I think it was, and maybe the AOJ determined it was not new and relevant, but if there was evidence of record, setting aside the new and relevant question, that evidence would be part of the record at the time of the agency decision
On the supplemental claim.
appeal. Yes, sir.
So, but are you in any trouble? Trouble is a bad word, but if are you in any difficulty in the fact that this is an odd case, in many respects, but you filed an NOD with respect to the higher level review decision. You never filed an NOD with respect to the supplemental claim. The board said, well, you didn't identify the supplemental claim, but we don't think you can appeal the original decision, so we're going to treat it as a decision on the supplemental claim. My point being, again, Mr. Terry may not be the person to be able to raise these arguments because you didn't appeal the supplemental claim decision and only sought to appeal the original one. But I understand your point about the fact that had you appealed both, arguably the evidentiary record on the supplemental claim would include the evidence that in theory was not new and relevant because that wasn't in the record arguably before. I understand, and so you should go back and answer Judge Greenberg's broader question now. Thank you, Judge Greenberg.
Of course. So the greater impact here, Judge Greenberg, is that claimants are being deprived of their statutory one review on appeal. It creates a situation where a claimant can never have their claim reviewed on its merits by the board if at the AOJ level, the regional office level, the regional office decided that new and relevant evidence was not received by the agency. The only way, the way the board has treated this here, the only way a veteran could have a merits review of their claim is if they had submitted new and relevant evidence. And anecdotally, I can tell you that setting aside the legal question of what is new and relevant evidence, which is hard even for attorneys, I think, to define or capture, that there are times when veterans file supplemental claims misunderstanding what is a supplemental claim, and they submit evidence that might be repetitive or might be the same evidence. And if they do that, if they make that mistake, they are then prohibited from board review of the claim on appeal. It also deprives the court of its jurisdiction to review agency decisions. The court's jurisdiction is premised on board decisions. And if the only board decision that a veteran has to appeal to the court is like Mr. Terry's, where the board has said, no new and relevant evidence, we're not going to re-adjudicate your claim, then that also constrains and deprives the court of its jurisdiction to review claims on their merits or review board decisions on their merits. Other impacts are it also disrupts Congress's dual goal for the modernized system. The primary goal, or the first goal, not the primary, but the first goal was to help VA to expedite appeals. And by doing so, they created the 3 lanes and the 3 subpart lanes for the board. And if a supplemental claim, is a trap, essentially, if claimants know that there is a risk involved in filing a supplemental claim, the board will quickly get out and claimants will stop choosing the supplemental lane. For Mr. Terry, if he had chosen the board review lane with evidence submission, he could have submitted the same exact evidence and the board without question would have reviewed it. But instead, he chose the supplemental lane, got a decision at the agency that there was no new and relevant evidence. And then that's where he found himself with the board. So it creates a disincentive for veterans to choose the supplemental claim lane because they're wary of getting stuck in this new and relevant evidence question. The other purpose Congress had was, of course, to preserve claimants' due process rights. And as I've said already, this deprives appellants or claimants of their due process rights. The board, 38 U.S.C. 7104. The board is obligated to give, decisions of the board shall be based on the entire record in the proceeding and upon consideration of all evidence and material of record. And under this interpretation of what is a supplemental claim and how it constrains the claim going forward, it's depriving veterans of that statutorily guaranteed review. So that's just a snapshot of the broader implications here if the board is not giving the full scope of review on the merits.
Thank you. I just have another question. Is the argument you just made, in your view, consistent with the statutory scheme established by Congress in 1988 with this court and the later statutory developments?
I think it is, and I think that it is it's not only consistent, but it's the only result. So it might be helpful to highlight briefly where the parties agree, because the parties largely agree on the scope of the AOJ September 2019 decision. This was a continuously pursued claim. Veterans file claims for benefits. Veterans do not file, the court said in Bernard v. Brown, veterans don't file claims merely to have the VA consider evidence. Claims are defined as requests for benefits. The parties agreed that the September 2019 decision was a decision on a claim for benefits. And we also agreed that that was a decision with respect to the same claim decided in April of 2019. So given the scope of the AOJ's review, 38 U.S.C. 7104, again, Congress intended that all questions in a matter shall be subject to one review on appeal. The Federal Circuit has described the board as an appellate tribunal hearing cases, if you will, out of the regional offices or the AOJs now. In DAV versus Secretary of Veterans Affairs, the Federal Circuit called the board an appellate body within the VA that reviews initial decisions made under 38 U.S.C. 511. That same decision, the court went on and said the board conducts de novo review of regional office proceedings based on the record. So I think that allowing claimants to appeal the claim, which is the claim for benefits, to the board and receive their, statutorily guaranteed one review on appeal, I think it's not only consistent with the statutes and regulations, but the statutes and regulations, they dictate that result. I don't think there is a world in which the statute could be interpreted to narrow the scope of an appeal coming from the AOJ to the board, given its existence as an appellate tribunal.
Thank you.
Of course.
Could you humor me and say that we're not that at least one of us is not going to want to wade into a factual scenario that Mr. Terry, in my view, does not represent, because the supplemental claim decision wasn't appealed, and we have this time issue, which was the original argument. So let's just pretend that you're only going to talk to me now about the timing issue. What's your best argument under the statutory language for that argument, which I understand to be, and you tell me if I get this wrong, right, that you can take any of the three actions listed. In your case, you couldn't have taken a higher level review because it was a higher level review. But generically, you can take any of the three. If that action that you choose ends within a year in a way that you don't like, your argument is, I've got time remaining. I can go back and take another of the actions that I didn't take. Assuming that's your argument on timing, because it deals with the year, tell me the best way you work through the statute to get there.
So 38 U.S.C. 5104C, right? it says that the claimant may take any of the following actions after the date on which the AOJ issues a decision with respect to that claim. Now, I know the Secretary has a different interpretation of what any indicates here, but I think when you look at the context of the statute, Congress was clear that when it said any, it meant you could choose any one of those options within a year of a decision with respect to that claim. I think Congress would have said, issues the last decision or the most recent decision with respect to that claim if Congress had intended that the decision or the appeal rather be limited to the latest in time decision. I also think the context of the rest of the statute, Congress has thought to prohibit concurrent elections of appeals. Congress has thought to allow a veteran to withdraw an appeal and choose a separate lane. So Congress thought this out, and they've thought out the manner in which they wanted to allow veterans to select these appeals. Again, I think to balance the sometimes competing interests of expedition of appeals for the VA, but also maintaining a veteran's due process rights. So I think the language that Congress has used in 5104C particularly dictates that a claimant has that option. I think Congress would have prohibited the option if they didn't want a claimant to take it, much like, my time is up, but much like they prohibited concurrent elections.
Let's add 5 more minutes to the time.
Okay. I can wrap up actually, but I
I
would
do
just
have a
say,
question.
oh, yes, ma'am.
Counsel, I have a question, as a follow-up question. In your position that you can take any one of those 3 actions within a year, is it your position that it's the first action that you take has to be completed first? Or can you do simultaneous?
No, Your Honor. The position is that each appeal must be resolved. And I think that is, Congress made that explicit when they prohibited concurrent elections. So I think that would fall within the scope of a concurrent election if a veteran or a claimant attempted to choose one lane while review of a separate lane on the same claim or issue within a claim, which is defined similarly as a claim of entitlement. But with regard to the same claim of entitlement, I think the statute is clear that concurrent elections of separate lanes is prohibited.
Okay. And now your position is that once an election is made and comes to conclusion, if it's within 1 year, you can opt for another option on that same claim, if it's within a year.
Yes, Your Honor, that is.
Now, in Mr. Terry's case, that was the case, that he was able to get a decision, a higher level review, well within the year.
Yes, Your Honor, that's true.
Then under your argument, he could choose another one of the leftover 2 options. Now, but isn't that just a case where Mr. Terry was fortunate enough to have a decision maker who made the decision within a year? Or are all decisions made within the year?
I won't speak for the VA, but I can tell you from experience that all decisions are not made within a year. So you are correct, Your Honor, that Mr. Terry did find himself in the fortunate position to have been within the year of, more than one decision on the same claim from VA. But you are correct also that not every veteran, and the Secretary brought this up in their supplemental brief, that not every veteran will find themselves in that position. And so there is an opportunity where a veteran could file a supplemental claim, not receive a decision within the year, and be prohibited from backing out of that decision and choosing appeal of either the initial decision or whatever came before the election of the supplemental claim.
Thank you.
In closing, I would just like to say that, if the court affirms the board's decision here, that decided that only decided the question of whether new and relevant evidence was received, the veteran's only option, Mr. Terry's only option, is to continue pursuit of his claim, is to file another supplemental claim. And for Mr. Terry, whose sleep apnea claim is dependent on the primary condition, the diabetes claim, and for which, regarding the sleep apnea claim, he has submitted evidence. Mr. Terry is in a position where he doesn't need more evidence. What Mr. Terry needs is he needs the board to perform a de novo review of his appeal on the merits, and that is the decision we would like the court to come to. Thank you.
Thank you.
Thank you, Your Honors. May it please the court. Your Honors, appellant opted into RAMP, chose higher level review. When he received his higher level review decision in April 2019, he had two choices. He could appeal to the board and have the board adjudicate his claim, or he could file a supplemental claim based on new and relevant evidence. He chose to file a supplemental claim and thus have his claim re-adjudicated by the AOJ based on new and relevant evidence. When that strategy didn't pan out and the AOJ denied re-adjudication in September 2019, his right to appeal the earlier April 2019 HLR decision extinguished, and his options for review as a means of continuous pursuit of his sleep apnea claim attached to the September 2019 decision. And because where a supplemental claim is filed, re-adjudication of a claim is conditioned on the presentation or acquisition of new and relevant evidence, the board properly focused on whether appellant submitted new and relevant evidence, and is finding that he did not, denied his appeal. While this might not be the outcome that appellant had hoped for, it is the outcome that Congress intended. Your Honors, the Secretary's position in this case can be broken down into 2 points. First, when the traditional tools of statutory construction are applied to 5104C, it is clear that Congress intended to give claimants the right to select a single administrative review option in response to an AOJ decision, and to continuously pursue their claims only through successive action taken in response to subsequent successive decisions issued with respect to their claim. It did not clearly intend to allow multiple reviews of the same decision made with respect to a claim. But, Your Honors, to the extent that there is any ambiguity here, the Secretary's regulations resolve that ambiguity and are entitled to deference under Chevron Step 2. Point 2, Your Honor, is that applying the same framework, it is clear that Congress intended that where a claimant files a supplemental claim, even in continuous pursuit of a claim, re-adjudication of that claim is warranted only where new and relevant evidence is secured. But again, Your Honors, even if Congress's intent on the matter is ambiguous, the Secretary's regulations reasonably construe that condition and are entitled to deference. Your Honors, when interpreting a statute, we first look to the language of the statute, and that analysis begins with the ordinary tools of statutory construction. We look at the text, the structure, and we apply the canons of construction. And under the Chevron framework, if Congress has directly spoken to the precise question at issue, effect must be given to the unambiguously expressed intent.
But so is your, the Secretary's position is that the Secretary's initial position is, you got to follow that, but your initial position is that 5104C is unambiguous.
That is correct, Your Honor, that Congress's intent is clear, and that intent is to limit one review action per decision rendered with respect to a claim.
And I don't want to throw you off your rhythm. You're going to be working through the statute, I think, from what you're starting. But I'll tell you the part that I am most interested in, you addressing, is subsection 2, 2A and B. A to A, B, right? In other words, what I see as the two sides of the coin, right? The prohibition on concurrent action, and then the statement that nothing in the subsection shall prevent a claimant from taking actions in succession. Okay? I'd like you to address that, because if in fact, I'll tell you one of the things about this that makes me have some difficulty with the Secretary's argument on this point is, if the Secretary is correct that choosing from among the three options extinguishes any other choices with respect to that decision, right? Then I don't know why Congress would then need to say any of this other stuff, right? Because once you chose one, it extinguished. You see what I mean? Saying you can't do them simultaneously, but you can do them in succession. You're talking about, under your view, a new decision on the claim, i.e. here, the supplemental claim. So in any event, that's the part of the statute I'm most interested in you addressing.
Well, Your Honor, I could start there, although with the caveat that those provisions do need to be read within the context of the whole of the statute. But
absolutely, and that's why I didn't want to throw you off, right? I just wanted to highlight to you that in your discussion of the structure of the statute, which I think is the most important thing, this statute, right? That's the part that I'd like you to sort of slow down when you get to, because that's the one that has been troubling me for the last few months.
Understood, Your Honors. Well, if we look first to the actual text, as counsel noted, Congress, paragraph A1 allows a claimant to choose any of the administrative review options. And that word any in isolation is an ambiguous term, because it could mean no limit as to the number of options, or it can be no limit as to which one of the options. And so basically that's an ambiguous term, Your Honor. But we have to look at the context. And the context is paragraph A1, which is the review after the initial AOJ decision. And while this case was a ramp decision, paragraph A1 contemplates the scenario where you get your initial AOJ decision, and so you can choose from any of them, meaning there is no restriction as to which one of those options that a claimant can take. So contextually, any most reasonably means any one of. Your Honors, looking at paragraph 82A, the no concurrent review of the same claim, Your Honors, that is what would result if paragraph A1 were read to permit multiple reviews of the same decision. Because while that first set of adjudications or reviews may not be done concurrently, the subsequent ones would, as the example that the Secretary had made in his supplemental brief.
And so just so I'm following you, sorry to be so pedantic about this, right? So what would you say to the argument that if the Secretary's position that you just articulated about one was correct, right? Meaning that meaning any one, and once you use that ticket, right? That's it, right? With respect to that decision, I don't mean to put words in your mouth, but as I understand it, that's your point, that you get a decision, and then you take any one of these three lists, and once you pick the one, then we sort of close the book on that decision. We've moved on to something else. Is that a fair colloquialism? Okay.
Yes.
If that's right, the problem I have with then going on to A2 is Congress wouldn't have had to say either you can't do them simultaneously, but you can do them in succession, right? Because once you had chosen one, under the Secretary's view of A1, the book on that decision is closed.
That is correct, Your Honor, but paragraph A2 doesn't say and doesn't express Congress's intent that a claimant can select multiple review options in succession in response to the same decision. What it does is it doesn't prohibit a claimant from taking successive action with respect to a claim. In other words, it makes clear that subsection A doesn't prohibit a claimant's right to continuously pursue their claim. So it gives...
Could I just ask then, wouldn't the same result obtain, though, under the Secretary's view of A1, even if A2 weren't there? Because A1 would say, I get my first decision, decision one, and under the Secretary's view, I can choose any one of the three options. Let me just get this out, right? because I'm working through it in my head too. Okay, I can do any one of the three options. So I pick supplemental claim. Okay, I then go through the supplemental claim process. I think I had understood the Secretary's view is that the supplemental claim itself is a decision on a claim, and therefore what you've done is you made your selection under A1 with decision 1. Now you're making your selection under A1 with respect to decision 2. And once you make that election, that decision's done too, right? Isn't that the sort of Secretary's point?
Yes, it is. It is a linear progression. You're constantly moving forward. You get a decision, you get a response to that. You get a decision on your review option. You select a new review option, and then you get a decision, and so on and so forth.
And so, in theory, if the statute just said A1, that would accomplish the goal of not doing things simultaneously, but being able to do them in succession. I'm not asking you to give up the whole case, right? But I'm saying that in a way, that's all you need from your perspective. You can do any one of the three according to the Secretary's view. You make the choice. It's like Robert Frost, the road not taken. You're never going back. You got a new decision you can pick from whatever others.
Right, and so that provision, that caveat is simply it's a clarification from Congress. It is not an affirmative grant of anything. It is a clarification that Congress wanted to ensure that this provision, that this subsection A wasn't read in any way to undermine or be inconsistent with, the rights under 5110, that right to continuously pursue a claim, because that's where the right to continuous pursuit stems from.
So what do I do with the fact that I can accept that, right? In other words, there are times that Congress puts in place merely for emphasis, right? Or as somebody once said long ago in law school to me, if you're really concerned about your pants falling down, you can wear belt and suspenders, right? So you do that. But on the other hand, you could also read section A2 as saying it's consistent with the appellant view, because you could say, instead of saying this is an emphatic point, right, which could have been accomplished by A1 standing alone, this is consistent with the idea that you can't do them simultaneously, but you can do them in sequential as long as you're within a year. If both of those are possible, why should we choose the more restrictive version than the more liberal for a veteran version?
Well, for two reasons. First is because that's not the end of the analysis, Your Honor. We do need to go further, and we do need to look at the overall scheme that Congress created and its purpose. But second, Your Honor, is because if the court views it as possible either way, then we still need to look at the Secretary's regulations, which do interpret that very issue, and they very clearly provide the right to take only one administrative review action in response to a decision. So, Your Honor, while it is the Secretary's position that the language of the statute clearly indicates Congress's intent to take only one action, to the extent that there is any of that ambiguity, Your Honor, then we look at the regulations. And that regulations, Your Honor, at note 3.2500C, a claimant may continuously pursue a claim by timely filing one of the three administrative review options. That same interpretation is elsewhere in the regulatory scheme. 8.30, which concerns review of life insurance decisions, applicants may elect one of the three options. 21.416B, claimants may elect one of the three administrative review options, and that's veterans' readiness and employment. 21.1034, under the same topic, claimants may elect one of those three. So it is very clear that the Secretary has made a clear interpretation of that language. So if there is any ambiguity, then we need to defer to the Secretary's interpretation. And that interpretation, Your Honor, is eminently reasonable because it is consistent with the goals and purpose of the AMA reforms, but also it is consistent with the legislative history, which, as the Secretary noted in his supplemental pleadings, include the Senate and the House committee reports, both of which indicate an understanding that a claimant gets one opportunity to seek review of a decision. In the Senate Report 126, they explained the effective date would be preserved if the individual continuously pursues a new option to be reviewed at VA under the new appeals system within 1 year of the latest decision. That's echoed in the House Committee report at 115-135. HR 222 would allow a veteran to maintain the original effective date of their claim, regardless of the number of times the veteran appeals the decision. However, to maintain the original effective date, veterans would be required to submit new and relevant evidence within a year of the most recent decision, and that was referring to the Court of Appeals as well.
I have a question about the ambiguity point. I'll tell you, though, on the legislative history point, I think this is it's not particularly helpful for me. Now, not because I won't look at legislative history, I will, but because the focus there really was on the continuous pursuit with respect to effective date. But leave that aside. I have a more conceptual question that was framed recently at the Judicial Conference for the Federal Circuit by Judge Chen on a panel, which is, if we get to this point about do we find it ambiguous, the statute ambiguous, we then would be faced with the conundrum that Judge Chen discussed, which is, do we go to Chevron, which says we defer to the agency, or do we go to Brown versus Gardner, which says we defer to a more veteran-friendly interpretation?
I do believe that this court, in its own precedents, has applied the pro-veteran canon only after going through not only the tools of analysis, but also Chevron, and that the Chevron analysis as well. So this court has previously indicated that the pro-veteran canon would not apply before Chevron Step 2, Your Honors. But again, I think more fundamentally, I don't believe that we would ever get to the veteran canon anyway, because when we look at that text, when we look at that context, and agreeing that there is some ambiguity in there, that ambiguity is still nevertheless resolved when we look at what Congress, when we're looking for Congress's intent, when we look at the purpose of the AMA, the purpose of these reforms, Your Honors. The purpose of the reforms was to streamline the appeals process. It was to finalize appeals in less time, with less resources, while still giving claimants the right to choose or to have some autonomy over how their appeals processed. If we look at the appellant and the amici's proposed position, it would defeat these purpose and goals. It would increase the number of decisions needed to finalize appeals. It would increase the processing time for appeals and create the very backlog that Congress clearly sought to eliminate.
Wouldn't, though, to follow up on a question that Judge Pietsch asked your friend on the other side, what I've characterized as the narrower view, right, which focuses on the 1 year.
Yes.
Right? You'd agree with me that would have a much less dramatic impact on the system than the broader view. Well, you'd have to agree with that because, right, I mean, it would deal with only scenarios in which the first decision is made within a year, as opposed to what I understand the broader decision to be, which is one could continuously pursue a claim for a decade by filing successive actions, and then the board would have jurisdiction to go all the way back to the initial rating decision.
I'm not sure that I do agree with that, Your Honor, and I say that because I'm not sure that for two reasons. The first, Your Honor, is that if claimants are allowed or viewed as being allowed to take multiple actions in response to a single decision made with respect to a claim, that would lead to potentially an exponential increase in the number of decisions needed to finalize appeals.
Well, except, let me just stop you there, right? It would have to, but the 1 year period would have would have a constraining effect of some sort. You and I sitting here today, Mr. Greenberg, we might not be able to quantify what that constraining effect is, but it would have a constraining effect, right?
It would, Your Honor, but presumably, because the similar language is used in 5110, that same argument would be made in that context, which is that logic would apply at every iteration or upon every decision leading to another review.
Well,
So-
yes, but again, the 1 year period, right? The argument that centers on my action number one in response to decision one has to be completed within a year for me to then take another one, right? I mean,
Yes.
the narrower version of the argument may not pose as many systemic threats as you're suggesting, just simply by the constraining effect of time.
But that constraining effect of time, Your Honor, should be viewed in the context of the Secretary's goals. And those goals are to significantly reduce the time it takes to process and respond to these review options. The supplemental claim in this case was decided, I believe, in a matter of months. The Secretary noted that the goal is the average of 125 days for supplemental claims and higher level reviews, and that the average time to actually complete them, I believe, was 30 days for supplemental claims. So, Your Honor, we're not talking that 1 year time period. Yes, it is a constraint, but it is not a constraint that leads to a manageable system. Your Honor, we can have an example where a veteran gets their initial AOJ decision, and within that 1 year period, they submit 4 different supplemental claims, each of which is adjudicated and denied within that 1 year period. And that veteran then decides that they are going to appeal 1 or 2 of those decisions to the board, seek a higher level review of a different decision, and then file a supplemental claim on the remaining decisions. And then those will result in decisions. And aside from the fact that, again, this idea of multiple reviews does violate Congress's prohibition on concurrent review. Even if we push that to the side for a moment, I think it is evidence how exponential the decisions can be. And the very reason that the Secretary is able to issue decisions quickly is because the process has been streamlined.
Well, and I'm not suggesting that this wouldn't cause some inefficiencies. I'm just saying that, of the arguments you're making, right? The argument that I'm calling the broader argument that was advanced by amici, and that could only be advanced by somebody who waits beyond a year, right? To chat from the original decision, right? That has much larger systemic context than this, because once you have that initial decision one, I'm going to call it, okay? The egg timer gets flipped, okay? The egg timer with the 1 year clock running, right? It is true, conceivably, you're right, that there could be multiple actions taken within that year. But there are a number of variables that can play out, including, for example, if we assume that a claimant like Mr. Terry filed their supplemental claim on day 364 of the hourglass, right? Under the narrow view of this, unless the supplemental claim was decided the next day, right, it would pass. All I'm pointing about is that I take very seriously when we're talking about systemic changes like the AMA, that it's going to have systemic change impacts on VA. The narrower version has less. It does. We might have to quantify how much, but it's got less.
Yes. I think, though, that Your Honor's part of your explanation, and perhaps I don't then disagree. I do think that both issues that are raised will result in unworkable conditions, and they would defeat the purpose of the AMA. But as Your Honor pointed out, that in a case where a veteran waits 300 and something days, they probably won't get a second opportunity to take to select a separate review option. But Your Honors, that supports the Secretary's point of view, because first, the appellant and amici's position that you can take multiple reviews would encourage quick decision making rather than the informed decision making that Congress clearly intended veterans to take when it gave them that 1 year period to decide which option to take that best suits their needs. But moreover, as the appellant recognized, this would create inherent inequality among veterans, not only based on when they choose to make their decision, but how long it takes VA to issue their decision. So, Your Honor, it is hard to imagine that Congress intended, in its improvement of the appeal system, to create a system that treated veterans unequally based on factors beyond their own control.
Well, I'm not sure, to tell you the honest truth here, I'm not sure a lot of people thought about this precise question directly. I think people might have assumed that there was a one choice, book is closed, move to the next. I'm not sure that people sat down and thought completely about it, and they wrote what they wrote. And I appreciate your argument on the statutory language, because that really is, for me, probably where the battle was won or lost.
And perhaps this wasn't an overly thought issue because, as you're right, the assumption was that forward-moving linear progression of the appeals process, because what this system was designed to do was to get rid of the back and forth, the constant re-adjudications, to set the process in motion so that you are constantly moving forward. So you're right. It was likely an assumption that a veteran would make one review option, get a decision, and then move forward. And Your Honors, again, that is reflected in the legislative history, and whether that's reflected because it was considered and debated versus assumed by Congress, I'm not sure that makes a difference, because it still reflects what Congress intended this system to be, which was a system that gave veterans a right to take one action in response to a decision, then to move on and take another action in response to that latest decision, and so on and so forth. But again, to the extent that there is any of this ambiguity, which I submit that there is not, again, that ambiguity needs to be resolved by looking at the Secretary's regulations, which clearly address the issue and resolve any of that ambiguity. Your Honor, because my time is running low, I was going to try to touch on the second argument, which, if there are no questions as to this first point.
I do have a question. We will give you time. With respect to what you're saying, Mr. Terry got a decision in June of 2017, in which he eventually opted for a higher level review. That was one of the three options he had. Then he got a decision in April 2019 on that higher level review. So, concentrating on that April 2019 decision, are you saying that an appellant has 1 year again to opt for the other options? So does he have another 1 year to go? Is he getting another 1 year?
He has, as I understand, he has another year in order to continuously pursue his claim, which would start from the issuance of that last decision. So
April 2019. And so he opted for supplemental review and then got a decision several months later. No, wait, no.
Correct.
Yeah, he got a, but in his 2019 supplemental review, supplemental claim, he referenced the June 2017. So is that what you're saying can't be done? Because that hasn't been a year, because it's been in excess of.
No, it's. I don't think so, Your Honor. But to clarify, it is that the appellant received his HLR decision in April 2019. He had a year to choose how to respond to that decision. He had a year to choose amongst the options available for review. He chose to file a supplemental claim based on new and relevant evidence. He then got a decision on that claim. Once he got a decision on that claim, his rights to review attached to that decision on a supplemental claim.
And with respect to the 2017 decision that Judge Pietsch was, you tell me if I'm wrong factually, as I understand it, that was a decision under the legacy system.
Correct.
He then got the ramp election. So then the first AMA decision
Yes.
is the April 2019 higher level review.
That
Is right?
that is correct.
So
yes.
that's the start of our journey under the AMA.
That's
Is that
correct,
right?
Your Honor.
Okay.
Your Honor, I would like to address the second argument, though, but I see that my time is running out, and I would ask, though, that if this is an issue for the court's consideration, given that this wasn't briefed by the parties, to allow the secretary to submit a supplemental brief if the court is unable to hear his response now, Your Honor, because I don't.
Go ahead and continue your argument. We'll give you more time.
All right. Your Honors, as to the second issue, that question of whether on appeal of a supplemental claim that's denied for lack of new and relevant evidence, whether the board is required to adjudicate the merits. Again, Your Honors, the Secretary's position that no. And it's foremost the Secretary's position that Congress directly addressed this issue in 5108, which specifically provides that if new and relevant evidence is presented or secured with respect to a supplemental claim, the Secretary shall re-adjudicate the claim, taking into consideration all the evidence of record. So again, Your Honors, Congress explicitly and expressly conditioned re-adjudication on the presentation of new and relevant evidence. And significantly, Your Honor, 5108 applies to all supplemental claims, including those filed within 1 year of a decision in continuous pursuit of a claim. Because 5104C A1B provides the review option as the right to file a supplemental claim under Section 5108 of this title. And this 5108 is also referenced in 5110, Your Honor. So again, Congress specifically preconditioned the adjudication of a claim where a supplemental claim is filed on there being new and relevant evidence. And again, Your Honors, even to the extent that the court were to find any ambiguity in that, the Secretary's regulations address that ambiguity. 3.2501 provides that if new and relevant evidence is not presented or secured, the agency of original jurisdiction will issue a decision finding that there was insufficient evidence to re-adjudicate the claim. And I'd note, Your Honor, that this position is entirely consistent with case law that on new and material evidence, in the sense that that case law recognized that there was a two-step process. If a request to reopen was submitted, then the board first had to determine whether there was new and material evidence, and only then, if answered affirmatively, would it address the merits of a claim, Your Honor. And we have that here. And Your Honors, to the extent that the appellant has suggested that there is, that there may be no reason that there's heightened risk with filing supplemental claims, that this is somehow an anti-veteran provision. It's not, Your Honor. That filing a supplemental claim is one of the three options that a veteran is given, and there are many benefits that flow from it. The foremost, perhaps, being the application of the duty to assist. Even without that supplemental claim being granted, the veteran can request the Secretary get records, Your Honors. Second, the veteran may simply get a decision from the AOJ and understand exactly what they need and have that evidence and present it, and then get a quick decision from the AOJ, as opposed to potentially waiting the longer time to get a decision from the board using the evidence submission lane. So again, Your Honor, there are advantages to a supplemental claim. And to the extent that there are risks, those risks have been mitigated to the fullest extent possible by creating an extremely low threshold, new and relevant evidence. Your Honors, it simply has to be new and it simply has to be relevant. I would add also that in that regard, that there are attorneys and agents available to veterans who may have questions, and that Congress also, as part of the AMA, amended the fee statute permitting paid representation immediately after the issuance of that initial AOJ decision, Your Honor. So the idea that veterans are caught off guard or that there's no reason to file a supplemental claim, there are benefits. There are risks and benefits of any lane that's chosen, Your Honors. Ultimately, Your Honors, in this case, the appellant does not like the outcome here, but the appellant's outcome should not be determinative of the proper interpretation of any statutes or the Secretary's interpretation of the statutes. It is not indicative of what Congress intended. Your Honor. And again, if we apply the legal framework, the appropriate legal framework, on both issues, Congress has spoken and has indicated both one review per decision on a claim, and two, that in order for there to be a re-adjudication of a claim, there has, based on a supplemental claim, there has to be new and relevant evidence. So, Your Honors, if there are no questions, I would then like to just briefly conclude. Your Honors, again, the appellant's position here is not only, and amicus position here is not only not supported by the statute and is inconsistent with the proper analysis under the legal framework, but again, it would undermine and defeat the very purpose of the AMA reforms by increasing the number of decisions needed to finalize appeals, by adding confusion into the mix, by creating the potential for concurrent jurisdiction, which again, Congress specifically provided no mechanism to deal with, indicating that it assumed that there would be no issues based on multiple reviews of the same decision. And also, Your Honors, again, it would disrupt that linear forward-moving process by allowing veterans to take a claim, get a decision, respond, get another decision, and then go backwards and essentially start over again. That's not what clearly intended, nor did Congress intend to muddy the system, to create more backlog, or to treat veterans unequally based on either making quick, rash decisions or the time it takes VA to issue them a decision in response to their election. Your Honors, for these reasons, the Secretary submits that the Board properly found that the appellant focused its inquiry on the fact that appellant had not provided new and relevant evidence, and that its decision should be affirmed. Thank you, Your Honors.
Thank you.
Thank you, Your Honors. When it comes to the systemic impact of the court's decision on this matter on VA, I think with regard to what's been termed the broader question here, the scope of the board's review, there is no systemic impact if the court were to hold that the board is required to give a merits review to appeals coming out of the AOJ. That is what the board has done for its entire existence. The supplemental claim within a continuously pursued claim is a new creation out of AMA. Until 2019, veterans couldn't file supplemental claims within the continuous pursuit of a claim. The supplemental claim is the old legacy request to reopen, where a veteran had to submit new and material evidence to reopen a claim. So with regard to the impact of the board or on the VA of modifying internal systems, I don't think there would be any impact if the court were to instruct the board that it must, under 38 U.S.C. 7104, give a statutory one review on appeal based on the evidence of record. Now, the Secretary has rooted his argument regarding the new and relevant evidence requirement for re-adjudication in 5108. Now, 5108, one, does not mention the board. It is an instruction. And in the instruction in 5108 is that if new and relevant evidence is secured, then the AOJ or the Secretary must re-adjudicate the claim. That completely jives with Section 7105 of the same title that allows a veteran to appeal their claim, the claim for benefits, out of the AOJ and to the board, where the board is statutorily required to give a merits review of the claim. And this is what the board has done. Again, this is what the board has done for its entire existence. Unless a veteran was requesting to reopen a claim in the legacy system, the board never questioned the scope of its review and how it should decide the claim. And Congress has thought of this when it drafted the AMA statutes, because in 7104 and in 7105, Congress has accounted for the fact that veterans can file the greater than 1 year supplemental claim. And in those instances, Congress has thought to express that for the board to re-adjudicate, a veteran then, under the greater than 1 year supplemental claim, must file new and relevant evidence. 7104 says that where the board has already decided a claim, for the board to then re-adjudicate that claim, the veteran must submit new and relevant evidence. 7105 says that if a claimant has filed a claim and allowed the 1-year period of appeal to expire before the AOJ, that claimant must then file new and relevant evidence before the board will re-adjudicate their claim. So the statutory scheme fits perfectly here and signals Congress's intent that a veteran should have a review of the claim on the merits. 5108 does not constrain the board's jurisdiction. Again, 5108 is an instruction, and it's an instruction that is referenced both for claims pending before the AOJ under 5104C. It's one of the options for appeal. You can file a supplemental claim. It's also included in the statutes with regard to the board, in that under those circumstances, if the board has already adjudicated the claim or the veteran failed to appeal it on the first time around, that the board statutes also reference 5108, and it's the same instruction. If new and relevant evidence is received, then the secretary must re-adjudicate the claim. But 5108 does not say that a veteran must submit new and relevant evidence to receive their statutory one review on appeal. 7104 is explicit that the board's review should be on the evidence of record. And again, this is what the board is used to doing through the legacy system. I don't think there would be any systemic impact on the board if the instruction came down that it was to, again, review claims coming out of the AOJ, out of the regional offices, on their merits. Now, with regard to the narrower issue here, this question of timing, the secretary has put forth the sort of apocalyptic view that it would exponentially increase the number of claims. But Congress thought of that, and they have prohibited concurrent election with regard to the same claim. And a claim is defined as the claim for benefits. The Secretary's own regulation, 38 CFR 3.151, says that issues within a claim are defined as specific entitlements if a claim application includes more than one claim. So if I claim a knee, a hip, my hip claim is an issue within that claim, and it is a request for a specific entitlement. And the statute says that where the agency has issued a decision with respect to that claim, the hip claim, my hypothetical here, that a claimant may not take another action. So a claimant would only ever have one appeal pending of a particular claim before the AOJ. When it comes to systemic impact, though, I don't disagree with the Secretary that this would be somewhat confusing. The Secretary alluded to the fact that veterans might need to hire an expert.
I'm sorry, you said this would be confusing. I didn't track what the this was.
I think that this is that option. I don't think your veteran or claimant on the ground would be savvy enough to understand that if they file a supplemental claim and they receive a decision from the AOJ, like Mr. Terry, that new and relevant evidence was not received, that they could then back out of that supplemental claim if they were still within the 1 year of an earlier decision and appeal that decision. And I think it's unfortunate that the Secretary would allude to the fact that, veterans have available to them VSOs or attorneys available. I think the goal of the system should be a system in which veterans can navigate it reasonably on their own. So I don't think that the statute would prohibit this apocalyptic scenario of multiple appeals at different levels with regard to the same claim, because the statute says one appeal at a time with regard to the claim. So again, in closing, for Mr. Terry, if the court affirms this decision, his only option is to file another supplemental claim. And for a veteran like Mr. Terry, he doesn't need more evidence. What he needs is the board to review it. And when it comes to the broader issue here, I think that the parties' agreement that the AOJ issues decisions on claims, and 38 USC 7104's requirement that the board review claims, one statutory review on appeal, requires the board to evaluate the claim at least once based on its merits, based on the relevant evidentiary record. And I don't think ruling like that would have any systemic impact at all on the board, because that is what the board has been used to doing its entire existence. The within 1 year supplemental claim and the question of new and relevant evidence is a development of the AMA. And this question before the board in Mr. Terry's case regarding new and relevant evidence is only a development out of AMA. Pending no further questions, that is all I have.
Thank you. Any further questions, Judge Greenberg?
No.
Judge Allen?
No, thank you, Judge.
That being the case, this case is
All rise.
I'm the only one, but our tradition is that we come down and bring counsel, so there you go.